Order number 20.
Finally, we are of the opinion that there is no illegality or perversity in the impugn order / opinion passed by the learned member, and accordingly the present petition stands dismissed, and the registry is therefore directed to return back the case accordingly. Interim orders stand back.
May I please vote? Sure.
In this case also, we do not find any reason to interfere in the order passed by the learned member MSFT, and accordingly the present petition stands dismissed. Interim order passed earlier is accordingly stands vacated.
28. Yes.
May it please, Your Lordship. Lordship, yesterday Lordship passed an order in an IA.
Yes.
My Lordship has passed an order in the IA yesterday that mental health review matter till the board says he may be kept in GMC psychiatric ward. The board sat at around 5 o'clock yesterday. Then subsequently they passed an order and he was shifted to Help Aid and NGO in Khetri with a direction that his mental evaluation to be done and state should provide his make him appear before the board. These are the orders by the district judge. My Lord, in view of that fact, the order that has passed is not yet online. Your Lordship may recall it. Otherwise, I have already filed a recall petition.
Okay, let it be there. We'll do the needful.
Should I press for the recall petition or
That's-
he may be kept in this, the order has already been passed. I'm deeply obliged. I'm deeply obliged.
Normal. Yes.
For listing of a case, my lord, for motion, my lord, tomorrow, my lord.
When did you file?
14/12, my lord,
When did all the order of the tribunal was?
February 2023, my lord.
What is the urgency?
I have filed, my lord, on 14, my lord.
What is the urgency?
Urgency, not, my lord. Before vacation, my lord. Tomorrow, my lord.
Okay.
Obliged.
My lord, item the 11, my lord, only one day I can pay accommodation, my lord. Today, upset personal problem, my lord. This matter become this, we filed against the order of the CAT, my lord. On 3rd of January, my lord, this. 3rd of January. File your.
May I please, your lordship, beg to mention item number 3, your lordship. Lordship, kindly this matter will taken after vacation, your lordship. Another prayer, your lordship, kindly, one prayer, your lordship. Listing for motion matter, your lordship. Serial number has been done, your lordship. Filed on,
When did you file?
filed on 13/12/2023, your lordship.
The date of the order of the tribunal?
Lordship, actually, I am on behalf of Mr. Yali, lordship. He's giving me or mentioning your lordship. For motion matter, your lordship. On tomorrow or
Okay, okay.
thereafter tomorrow, your lordship.
Tomorrow. Don't keep
Lordship.
anything for day after. You'll not get any order.
Lordship,
Because they will not be available from 23rd.
lordship.
Don't keep anything for 23rd, 22nd.
Lordship.
Maybe lordship. My lord, prayer for listing of one matter for withdrawal, my lord. My lord,
Tomorrow.
my lord, deeply lordship.
Maybe it mention IA civil number 3735 of 2023 in Met Appeal 52/23. Lordship, the matter came up yesterday, but it didn't came up yesterday. It's item number 23. Maybe listed on 22/12.
After vacation. Because my sister will have single bench every day. So she has to write. Because there are heavy pressure on bail matters. So that is why it has been given to all the courts.
Which means
Sister has to rise early.
on the
Immediately after reopening,
on 3rd of January.
3rd, 5th, any that you give.
May I, Lordship, I beg to mention item number 6 of daily list, Lordship. Kindly adjourn for the day.
Not for the day, it will come after vacation.
Yes, Lordship. Oblige you.
May I please your lordship, I would like to mention for listing of a writ petition, your lordship. The petitioner is in detention, your lordship, since 31st/10/2023.
When did you file?
Today, your lordship.
Do you have the number?
Yes, your lordship.
It will come tomorrow if it is not defective.
Obliged,
Come
sir.
tomorrow if it is not. Don't keep anything for Friday. You will not get any orders. It's clarified because they will be busy. They will not be available from 23rd.
May I please, your lordship.
Yes.
My lord, I'd like to mention item number 4. Some accommodation, my lord, because of personal difficulty, and my friend from the other side was supposed to get some instruction. She also has not
You'll
received.
have it after reopening.
Okay.
Okay. They have it.
Or even after Bihu, my lord, she has to get the instruction also.
Let it come after winter. After winter vacation.
Deeply obliged.
Yes, Mister.
Yes, my lord.
How's your health
Item
now?
now,
Feeling better?
just, yeah, just 3 days ago, came from hospital. Now it's,
Take rest. Health
yes,
comes first.
yes.
Why you are here?
Summer vacation is coming.
Would have sent your daughter.
Daughter is here outside.
Yes, what's your submission?
13 and 14, my lord. The admission matter, my lord.
Huh.
I already, my lord, became infectious. My lord.
I has become infectious.
Yes, my lord.
Whatever the main repetition.
Main admission now, admission position, my lord. LCR
Yeah.
already
You
received,
want to
my
go
lord.
today?
My lord, after vacation.
Okay. Yes, Mr. Rathia, we'll do that.
13 and 14. Obliged.
Depend on what's that. Yeah. thank you.
Nothing, Lordship. The last order, Home Department was supposed to produce whereabouts.
Yes,
report of
Lordship.
the-
A proper instruction is not received, Lordship. Some more time may be allowed, Lordship. 1 week time may be allowed, Lordship. Instruction was not given properly, Lordship.
Pursuant to the impugn opinion dated 09/07/2018 passed by Learned Tribunal, Furnace Tribunal, Roman close, Lakhimpur, not Lakhimpur, in LFT-2, Roman close, case number 616/2015 within bracket, district number 169/06, whereby 9/7/2022. The proceeding, namely Munna Biswas, was declared to be a foreigner, declared eligible, appointed. Under the Foreigners Act 1946.
Lordship,
May I please, Lordship?
Lordship, this is regarding item number 1. And Mona Biswas is regarding item number 2. Lordship.
Sorry. File was-
This is Lordship regarding the missing status of the petition, Lordship.
Hey, Hari, more প্রথম to direct knowledge to direct. LGB hospital. Please take your seats. Yes, continue. Yes, continue. Babur. itu believe it. Oh, no, like it. নালাগে তো আপনার কাছে করলে মাদারলি ফাইল করবে না হলে একটু করতে পারি অ্যাপ্লিকেশন নাম্বারটা হচ্ছে On the next date fixed, the Superintendent of Police Border Nagaon, response number 4. As well as the authorities in the Home Department of the state, response number 2. Shall apprise the court about the up-to-date status report relating to Kochiatali Police Post PPGD entry number 250 dated 15/02/2019 regarding missing of the petitioner. Was declared to be a foreigner by the learned member Foreigners Tribunal number 9, Nagaon. Right. In FT case number 98/2015. Right, order dated 19/02/2018.
Obliged.
Politically excellent. And he was taken into custody. And kept in the detention center at Tejpur. However, he was released from the said detention camp, Tejpur, during the COVID period. Mr. Pargiri Learned Counsel appearing for the petitioner submitted. As on date, come to petitioner, Munna Vishal. He has no instruction after such release from the petitioner after his such release. On the next date fixed, the authorities in the Home Department of as well as the Superintendent of Police Border Lakhimpur response numbers 2 and 7 respectively shall apprise the court about the whereabouts of the petitioner was declared to be a foreigner. Placed on twenty-third of January. Copy of this order be furnished to Mr. Z. Sharma, Standing Counsel, Home Department. Is necessary and for his onward communication. Yes, Mr. Sinha.
Yes, my lord. There's an order to furnish some certificate of his brother, money, brother of the petitioner. I could not submit till normal. I did not.
Mr. Sinha, Counsel appearing. For the petitioner. And Mr. A.I. Ali, Standing Counsel. Election Commission of India for the response number. Also heard Mr. G. Sharma, Standing Counsel, Home Department, Assam for the response number 4 and 6, as well as Mr. B. Sharma, Additional Senior Government Advocate, Assam for the response number 5. On being referred by the Superintendent of Police Border Dhuri. Police reference FT case number 50/2007. After hearing the petitioner and other parties, considering the evidence adduced by him, the learned member of Foreigners Tribunal number 1 Dhuri in FT case number 18/EBB /17 by the impugn order/opinion dated 07/02/2022. Appoint the petitioner to be a foreigner under the Foreigners Act 1946 of post 25/03/1971 stream. Dissatisfied with the said opinion, that such and such petitioner has filed this said petition on 24/07/2023. Issue notice returnable by 8 weeks as such and such, no formal notice. Steps by tomorrow. 1, 3, 1, 4, 5, 6. 1, 2, 4, 5. CGC from the deputy CITD. Steps on the response number 3 by register posted. Providing it. In the meanwhile, the petitioner had not been taken into custody pursuant to the impugn opinion dated such and such. They shall not be taken into custody and shall not be deported from the territory of India subject to the condition.
Obliging. May I please, Your Lordship?
In this case, your lordship, Home Department was asked to pose an inquiry, your lordship. Because in the voter list of 1966, the village name is shown as Kaunervita. And in the Kabin Nama, your lordship, the village.
Mr. A. M. Ahmed, counsel appearing for the petition. Mr. AL. This is for two, sorry. This year for two. Mr. Z. Sarma, Standing Council Home Department, that's number 3 and 6. E. Sharma, 5. Opinion dated 20. Superintendent of Police Board. Very in opinion, class order 21 to landed member for us tribunal 1 to agree. In case number FT case number 792/F/15. Within bracket, police reference FT case number 195/2015. Appoint a petitioner to be the foreigner of post 25/02/1971. Foreigner under pronunciation. So, and file the justification of 17/08/2023. Notice it appear before Superintendent Police Board to bring on the 6th of. Next date of listing of steps.
Oblak.
Yeah, please, your lordship. MCL has not come, so the registry may be directed to send a fresh recommendation of MCL.
Where was the office note? When did you appear before the SP board in Nagaon? When did you appear?
Lordship,
When?
Bill कितने लग से?
Lordship, the order passed on 2012-23.
When the petitioner appeared before the SP board in Nagaon?
कितने पेपर को अपनी है करो?
Lordship, they appeared.
When?
Lordship, sorry, I'm not.
Then we will vacate the stay order.
Lordship, appeared there. Lordship.
When? That's the reason we are asking you when.
Lordship, exact date I'm not.
Get the information, otherwise vacate the order. We'll verify it from the Mr. Sarma.
Lordship.
Get the information, give us at 2 o'clock, whether he appeared or
Yes,
not.
Lordship.
Otherwise, we'll vacate the order.
Yes, Lordship.
9.
It will be taken up at 2 o'clock.
Yes, Lordship.
May please, lordship. My lord, contested case, impugned order at page 89. My father adduced witnessed at DW2, lordship.
Heard Mr. M.I. Ali. Sorry, M.I. Hussain, counsel appearing for the petition. Z Sharma, 2. 6, 7. AI Ali 3. P Sharma 5. In opinion, dated 13/07/2023. Caused by member Fairness Tribunal, Assam, Forfeita 11 at Sorbo. In case number BPT/11 F.T.2152/2017. I am dedicated 2065A. Yes. It's a- Hearing. Declare the petitioner to be a foreigner of post 1971. Foreigner. Notice returnable vehicles. Appear before Superior Police Board, Nagaon, Borpeta, on or before 6th of January 2024. You have steps tomorrow. Steps on the responding. One appear one. Service on the PSDL model. Steps on the responding. Provide additional procedure. Please before admission, immediately on receptor left records will be concerned. Understand. Please for it with date to be raised. On the next date of listing. The petitioner shall apply this to when he appeared before the and she not he. Understand. To when the police user.
And
Ola is
My lord, in item 10, my lord, I have given my lord, the instruction, my lord, in the form of a chart. My lord, at paragraph 3, the comparative chart where both husband and wife stayed together, my lord. I have total 9 years, 2 months they have stayed together, and 3 spouse posting has already been availed by the petitioner.
But just tell us one thing. Great Pole Post,
My lord.
cannot be accommodated or what? Had been the post, the exigencies of services such. But for a Great Pole maintainer, washerman, all do you think this kind of problem?
My lord, is always subject to my lord vacancies, my lord.
See, we know that. As you know, have been some technical post or administrative post. The service is highly required. This is a different, the doctor, the engineer.
So she's IR
This
service
is an IR,
nurse.
Great Pole Post,
My lord.
not a nurse. Cannot be considered.
Well, under the rules for posting, my lord,
understood. Considering these aspects, sometimes, see, normally we follow the law. Sometimes we make an inspection, season IR. Grade 4 employee. Husband is a constable, right? Whether cannot be considered.
Your lordship, may I please?
Hold on, we're asking.
my lord, Lord, actually, my
There
lord,
is
she
a
was,
possibility of consideration. Our matter. Says from Tripura,
my lord.
right? Initially, they stayed at Tripura together. Then at Jolam, then at Dimapur or Impal somewhere. Get together. But the husband was transferred back,
Yes.
right? So that way, whether it cannot be considered.
Not already, my lord, because
We understood earlier she was there for certain period of time. There is no doubt about it.
my lord, you
But
speak.
exigencies of service for an IA, grade 4 employee, and exigencies for a service of a doctor or an engineer or a technical person or someone in the administrative side,
My lord.
prepared in the defense personnel is something different. An armed personnel is required at the border. Perhaps you can understand in the exigencies of service when there is situation, right? Maybe at a possible when there is requirement, the border area. But for an IR, do you think that
My lord, while passing the speaking order, the authorities have considered and the grounds for rejection was administrative constraints.
that's good?
But that will have to take an inspection, my lord.
That's the reason we are telling you.
My lord. Lord, I will take it instruction whether,
Considering the fact that she's a grade 4 IR, that's all, nothing else. It's been some, that exigencies of service for an IR and exigencies for service of a doctor.
No, no,
engineer.
no.
Find out, Mr. Gupta.
My lord.
If it is, see, basically, you know, in these units, I can understand. Thing is this, both has to consider all those aspects. If possible. We're not passing any order. at this
No,
Find out from them whether it can be accumulated.
no,
Possible.
no.
Tell us when. After vacation.
No, that's correct. Immediately on the reopening, my lord.
Give us a date.
For calendar 9.
Third, fourth, fifth,
My lord.
other periods.
My lord.
Immediately after reopening,
No.
then it starts from age of. January. When do you?
On 10th, my lord, 10th, 10th of
List on 10th of January. Enabling Mr. H.K. Gupta and CJC appearing for the correspondence. Enabling him to apprise the court as to whether the prayer of the petitioner can be considered or not. C being an IR in grade 4 service. The respondents.
Obligation.
And whether in incidents. Well, considered for a test for.
Made with the lordship.
Yes, ma'am.
This is a very unfortunate incident, harassing the common citizen by police without any authority, my lord, without any legal provision of the act. There are two acts bearing manner where they have alleged. Here, my lord, the petitioner was called on in the evening of 9, my lord. He was, a telephone call came from him, my lord.
Just a
when-
minute.
Yes.
Whether the petitioner approached the police accountability committee or not.
Yes,
Well,
Have you
yes, my
stated
lord.
so? Where, in which paragraph?
Not now, my lord.
Then you
Slowly,
approach
my
once,
lord,
then you
slowly,
consider.
because
Otherwise,
my
no.
lord, the certain things are in Jimma, that also be, my lord,
Place
because,
it before, you place it.
yes, my
before
lord,
the police accountability.
alternately will go, my lord, in the next year, my lord.
You
And my
approach
lord,
the-
some violation is there regarding my
Consider
lord.
your case, but first you approach the police accountability committee.
There is a provision also for appeal, section 12.
Without police, without taking the transit remand, my lord, without informing the
Definitely.
family members,
If it is
so many
right,
violations are there, my lord. So I thought is the only solution, my lord.
at this
They have
stage,
got
we are
very
not doing
limitation,
anything.
my lord.
They might have certain kind of information which you do not know at this stage. But you should have approached the police accountability committee since you are agreed with the actions of. the
Police,
part
my
of the
lord,
police
we have given copy to the home commissioner and my lord, the DGP.
That will not do, you are aware of the provisions. You
They
should
have got
approached-
limited, yesterday I talked to my lord, my lord. So my lord,
You
there is
just-
some very
you
limited
first
scope.
approach
They
the
have got
police
very
accountability
limited scope.
committee. You first approach the police accountability committee with your grievances.
But
If it is
the-
not
I
considered
want
by
the
the
interim
committee,
order,
you
my
will
lord.
consider.
I don't want the interim, lord. The legal provision is that, my lord, he is not dealing with any cattle or my lord, slaughter of cattle or
We are
anything.
not on that.
All licensors are there.
Yes, Saikya, we are
Number
not on
one,
that.
it's a violation of the, my lord,
We
Constitution of
are
India,
not
my
on
lord.
that. You are saying this is your prayer is that they have. In high-handedness, they have taken you without any such orders and all. You approach
Now,
the
my
police
lord,
accountability committee.
kindly listen to me, madam. Number one, my lord, the Cattle Act, that is, does not apply. And he has no jurisdiction under section 11(1) to go beyond his jurisdiction. That is, my lord, he has come from, my lord, Sriampur Gate. Section 11 is clear, my lord. Section 11(1), that beyond jurisdiction, he cannot get. The SI has to local limit, within his, he can operate within his local limits, number one. Number two, my lord, is that, my lord, under the Food Safety Act, my lord, FSSI Act, that are guidances, they have only the authority, sole authority to deal with the, my lord, processed food and other thing, my lord. For examination, taking, there's procedure of taking samples and everything, my lord. So this is, my lord, violation of, gross violation, my lord, of the police accountability will not, my lord, go into all these things, my lord. At DK Basu's case, if your lordship DK Basu case, 77 now. That is a different provision, my lord, that is one administrative. Different people like. What is the mandate of my lord arrest? Your lordship will, DK Basu's case, my lord, 11 points were raised, that I would like to read, my lord. Requirements for arrest and detention. The DK Basu guidelines were laid down in the case about the basic requirements to be followed when the arrest of a person is made.
Yes,
The
Mr.
11
Sharma.
provisional guidelines. I have copy him, Nikki. We have approached the commissioner and the DGP.
There is a provision, appeal provision also is there. As per Assam Cattle Reservation Act 2021. And section 12, appeal. Any person aggrieved by main order passed by the section 7 and section 11 may within the
No
30
order
days
passed, no?
from the
order
date
passed.
of receipt of such appeal and session judge having jurisdiction to our area in which the property and which such order related to has been paid.
Go through
And they have
section
not
11.
filed appeal also.
So section 11, here no order is passed. He don't have any jurisdiction.
Section 12 is there is a provision, man.
We go through first section 11(1). Whether he has got power or not. For the purpose of enforcing the provision of this act, a police officer not below the rank of sub-inspector or a registered veterinary officer or any person authorized in this behalf by the state government shall have the power to enter and inspect any premises within the local limits of jurisdiction. of such person where he has reason to believe that an offense under this act has been known. And this cattle like deals with, my lord, live cattle. Live cattle. This is a process made by. So if your lordship refuse to interfere, that will be very unpleasant. Transit remand also not taken, my lord. No transit remand, no seizure list, no arrest warrant.
That is good.
They have violated both the provisions of the act, my lord.
MS N. Sekel and counsel appearing for the petition. And Mr. P. Sharma, learned additional senior government advocate Assam, for the respondent numbers 1, 2, and 3.
In spite of even what is
Submitted on behalf of the petitioner that he is a practicing lawyer and looking after his family business. On 09/12/2023, around 6:30 PM, the respondent number 4, Sub-Inspector of Gusaigaon Police Station, Srirampur Outpost, District Kokrajhar. Please take your seats. Called him over phone and asked him to report before the Basista Police Station. The said respondent 4, on appearance of the petitioner before the Basista Police Station, directed him to take him to his cold storage premises located at Khanapara, where the police personnel searched all the computers and sealed of the cold storage compartment. Thereafter, they took him to Srirampur Outpost.
without taking transit remand.
Without taking any transit remand. Keeping him there without any warm cloth or other necessary things. Subsequently, petitioner was taken into custody in connection with Gusaigaon Police Station case number 381/2023, registered under sections 420/406/468 of the IPC, reviewing section 13 within bracket 1 of the Assam Cattle Preservation Act 2021. While detaining and arresting him, the police personnel from Gusaigaon Police Station read by the respondent number 4. Illegally seized one of the chambers of the cold storage, his cold storage building. Two of his mobile phones, etc.
Personal.
Petitioner submitted that his cold storage has got valid license from FSSAI of the Government of India under Food Safety Standard Authority Act 2006, as well as valid trade license issued by the Guwahati Municipal Corporation, being the competent authority. Petitioner submitted that in violation of the law laid down by the Honorable Apex Court in the case of D.K. Basu, the respondent numbers 3 and 4 acted illegally and taken him into custody from Basistha to Sirampur outpost without any valid transit order and detain him in custody. It is also submitted that he was released on bail by this court on 12 by an order dated 12/12/2023, first in bail application number 4507/2023. Hence, this writ petition by the petitioner, praying amongst others for a direction to the official respondents herein for a direction to an inquiry by a competent authority, and after inquiry, if the respondent number 3 and 4 are found to be guilty, should be punished. They should be punished under the law of the land. And further, to direct the respondents herein to pay compensation for torturing the petitioner physically
Medical issue also there.
and mentally.
In spite of medical opinion, he was not.
And further, bottom to also like to direct the respondents to pay compensation as the companies relating to the petitioner have incurred financial as well as financial loss and also affected his business. Affecting the reputation of the companies, as well as to remove the seal of the Eden cold storage owned by him, as well as to release his vehicle.
Personal vehicle, that is personal vehicle.
Bearing number such and such, and the 2 mobile handsets. It is submitted by, on behalf of the petitioner. The actions of the respondents clearly reflects the highness of the police personnel, particularly the respondent numbers 3 and 4. And it is stated that the petitioner have informed the Home Commissioner about such action of the this particulars, particularly number 3 and 4 in that case.
Home Commissioner Hamza. They keep it on record, my lord.
Mr. Sharma, under the additional senior comment for some submitted that the Assam Cattle Preservation Act 2021 as amended clearly lays down the provision of appeal, and therefore, if the petitioner is aggrieved by any such action on the part of the respondents,
Order pass karan hai ko? No order pass, my lord.
he may prefer an appeal under the same 2021 Assam Act,
Are some jurisdiction in
submitting that the petitioner was arrested connection with the Gosaigaon Police Station case number 381 of the 2023. Contains 13 repeat on the Assam Cattle Preservation Amendment Act 2021.
Since he has no jurisdiction, my lord, and no order is passed, so how can I go for appeal? Your lordship, may kindly note it down.
16.
No order passed, my lord. It is in the investigation stage.
Please take copy. Memorandum.
Yeah, the most probable.
Something.
Jurisdiction, my lord.
The entire facts of the case
Can your lordship give me 1
Relates
minute?
to-
my lord?
high-handedness of the police personnel. After going through the statements made by the petitioner in this petition, we are of the opinion that the petitioner has the remedy by preferring appropriate application before the Assam Police Accountability Committee for redressal of his grievances. As the matter relates to the allegation of the illegal action on the part of the police personnel, more particularly respondent numbers 3 and 4. Considering the above, as the petitioner has adequate alternative remedy for consideration of his prayer by the Assam Police Secondary Committee, at this stage, we are not inclined to interfere in this writ petition.
My lord, what about that?
Accordingly,
Interim order, my lord. Is rejected, my lord, yes, on Monday.
accordingly, this at this stance, it's not accepted as the petitioner has indicated sufficient of file. However, it is made clear that if the Police Accountability Committee has something that will consider the prayer of the petitioner. He may approach the appropriate forum. But the above observation, it's a petition.
My lord, regarding the interim PR, my lord, personal vehicle, mobile, everything there, and the Zima is rejected on Monday, my lord. We didn't get the order, but my lord, what about the accountable commission will close, my lord?
Not before the petition. If the
It will be closed, my lord, dear.
If the Jimma is rejected,
Yes.
where to approach, not before the report.
And my lord, there is violation of several provisions of the Supreme Court of India. So my lord,
Is it-
police accountability, whether they
Definitely
will be
look into
competent enough to, my lord, interpret the violation of the Constitution of the India. my lord.
Ma'am, there are
Different
certain
provisions of Constitution has been, my lord.
passed by our High Court. Sitting singly against the, not against.
Category
the orders
of
the-
case, my lord. I got,
Let us see. If you
Honorable
consider-
Justice Ranjan Gogoi has given enough relief, my lord, in my case, my lord, in several cases of the clients, my lord.
Let us see.
And
Because
my
we are
lord,
asking- we are
it
not
was, that was
against this.
listed before single bench. Nowadays, the court has been changed, so it is listed before the, my lord, exactly similar case, my lord. And he has given enough
Not
relief, my
against
lord.
this. You approach, then you see. If it is not.
Police
considered, then-
accountability, I don't think so, my lord, they can give,
If it is not
exercise
considered-
their constitutional power, my lord. It's entirely constitutional
See,
power.
your prayer
Where,
is
my
to
lord, if I
take-
charge, my lord, the orders I will get, my lord. In other cases, my lord, where the honorable court has protected the right and liberty of the petitioners.
You approach, if it is not considered, we are there.
And my lord, all are violations, rule also violations, they don't have jurisdiction also. Earlier, my lord, in cases, my lord, given relief, my lord.
It please your lordship. Lordship, this is a contested case, order dated 26/12/2019. Lordship, the impine order is in page number 35. Lordship, the same tribunal has held his brother, elder brother, citizen, Indian citizen. Lordship, that order is in the page number 100, annexure 25.
সেইখন আমাৰ
RMS. As from council appearing for the petition. So AI list and council. Let's. Also heard Mr. Deaton, attending council from Department Assam. Leadership number 3. As well as Mr. P. Sharma. This was number.
Lordship, kindly make grant interim lordship.
Where is your explanation?
Lordship,
Where is your explanation? For the delay in preparing this writ petition? The order was passed on 26th of 2019.
Lordship, however, explanation is not written on the writ petition, Lordship.
On being referred by the Supreme Court in this order, Malvari. The Learned Tribunal, Learned Furnace Tribunal, Baksa, Namalpur. In FT case number 2525 oblique Baksa, Baksa is in capital. No? Oblique 2016. Within bracket. SPB Nolbari reference IMDT case number 1582 oblique 2000. After hearing the petition. And the other party, considering the evidence produced by him. By the Indian opinion and order dated 26/12/2019. Declared the petitioner to be a foreigner. Under the Foreigners Act 1946. of post 25/03/1971. Dissatisfied with this in opinion dated 26/12/2019 of the Finance Tribunal Baksa Tamilpur noted above. The petitioner has filed this petition on 05/12/2023. After about 4 years. That too, without explaining any ground for delay in preparing the same petition. Preparing it. It is contended by the petition that the same Finance Tribunal earlier, not earlier, later on 28/02/2020 in FT case number 2526/Baksa/2016 declared, declared his brother to be an Indian national, not a foreigner. The foreigner since dispose of the reference of the Supreme Court Police border non-body in affirmative. Issue notice returnable by edicts as rarely affected by 2, 3, 5 and 4. Steps tomorrow. Step number is the portion number 6. Appear before Supreme Court Police border Baksa on or before 6th of January. The other last point maintainability of this petition shall be considered at the time of its admission stage. Pertaining to delay in preparing this petition by the is this matter for epic?
Much obliged, Your Lordship.
Now, please, Your Lord.
No, my lord. There is no, my lord, inquiry against the petition number 2 to petition number 6, my lord.
If you sit. Mr. Sharma, have you gone through the record?
Yes, Dr.
Mr. Pai? Mr. Sharma, vote. You go to the records and tell us. We have platinum. We'll take it up at 2 o'clock. Go to the record.
My lord, this is an expert opinion, my lord. Opinion is at page number 20, my lord. The petitioner was detained on 31st of October. We have also filed an IA for release, my lord.
Just tell us one thing. You are aware of the fact that a proceeding was pending
My
before
lord,
this tribunal.
my lord. My lord,
And definitely you are also aware that the order was passed against you.
no, no, my lord, I was not aware,
Yes. You have become aware only after 4 years when you were arrested.
my lord.
Why? When you are aware of the fact, a proceeding was pending before you in this tribunal.
My lord.
Why you have not taken steps for 4 years?
But ideally, I completely agree with the lordship. The
Hmm?
petitioner should have taken a step, but they,
Where is the illegality?
my lord, may I say this, Your Lord?
Where is the illegality in this order?
My lord, the petitioner, the opinion was passed because she couldn't appear. So now that she's in
You can
detention,
appear before the tribunal immediately thereafter. For certain reason you have
because
now
they engaged,
after your detention in the transit camp,
my lord,
you have become aware.
my lord,
You have made a mention yesterday,
my lord.
right?
Yes, Your
And
lordship,
accordingly, show us that in these 4 years,
my lord.
what she was doing.
My lord, may I say this, Your Lordship? The petitioner is a very poor lady.
We understood.
She's a senior citizen.
That doesn't
She
matter.
couldn't pay the lawyer.
See,
The lawyer subsequently didn't inform her. Now, these are people from a very rural background. They don't have idea of the consequences of this order, my lord. That is
See,
my humble submission, madam.
you are aware probably with regard to the proverb and particularly with regard to law.
I completely agree with your lordship. I completely agree she should
Then-
have approached the tribunal. I completely agree with your lordship.
Yes, get the records, we'll see. We are not passing any order at this moment. This cannot be,
Lord, she's a senior citizen, at least. my lord.
whatever it may be. At this stage, you cannot play with the laws of the land. You are not allowed to play with the laws of the land.
Had she been an educated person, I mean, my lord, she is completely.
Whatever, that cannot be a plea. Yes, Mr. Sharma. Today is
20th, my lord.
on 3rd. Get the records. 3rd of January. Get the records. We'll see. They're not passing any order at this stage.
Fourth or after third or before third.
4th, not beyond that. List on 4th. Enabling Mr. Z. Sharma, Standing Counsel, Home Department. But on 4th, if you do not produce the record, we'll pass the order. To place the records in original pertaining to FT case number 42/Baksa/2019. Wherein the learned member Fairness Tribunal Baksa, Tamulpur, on 23/12/2019 by an expert day order appoint the petitioner to be a foreigner under the Foreigners Act 1946 of post 25/03/1971 stream. As she, in spite of receipt of notice and appearing in the matter to her counsel, did not take steps since 29/06/2019. List according.
Obliging.
The last motion has it done? The motion last. The next motion.
Normative. No, Speaker. Very tiny.
For admission, item number 15.
The time being heavy at us.
That was a two. I think, which item?
Time being a motion matter, item 8.
That was at 2 o'clock. It will,
Yeah, please, your lord. The LCR was called for another in this case. The MP order is at page 20, my lord. Whereby my petition has been rejected. Res judicata petition, my lord. Page 20, annexure 5.
we'll have it after vacation.
My lord.
It will take time.
My lord.
Records are here.
The date may be kindly be fixed.
It will come immediately after winter break. List after entry. That's
Obliged.
Or next to various BCS. Attire to. That will let me cover that, the. Yes. Make the thing. Supplementary. Supplementary. Let me check the work of the- Get to the-
The act is amended, my lord. So they don't have only grievous injury or custodial death, they have jurisdiction. So here the violation of rules and other things also, so they cannot interfere and entertain the petition. So let it come tomorrow, my lord, your lordship.
Rupam. On the prayer of the council for the petition and list tomorrow. It will be listed tomorrow for motion.
Tomorrow for motion. Obligement.
11th of October 2023. On 11th of October 2023.
Item 8.
Yes.
Direction are given on or before 13th. Yeah.
Or Mr. Ayuddin, council appearing for the petition. On being inquired, Mr. G. Sharma, Standing Council Home Department informed, apprised the court that the petitioner appeared before the Superintendent of Police order on 11th.
Yes, Lord. 11th of October, 11th and
11,
2023.
3% to the order at the 2709/2020. From the office note dated 14/12/2023. It is noted that the relevant records from the concerned ordinance tribunal is yet to be received. Issue notice, issue reminder for the records of FT case number 201 of 2014. The office of the Fairness Tribunal passed Nagawasa. List on 8th of January.
We have to for my lord issue formal notice.
Let us see the records come.
I am obliged.
Yes, we heard you, but the record is yet to be called for. So we have decided that it is better if we have the original records.
Lordship,
While considering the matter, found that the records in original pertaining to JFTR case number 1773/2017, wherein the impugned opinion dated 24/04/2019 by the learned member Fairness Tribunal, Kamrup Rural number 1 is necessary for adjudication of the case. And call for the records of JFT within bracket R case number 1773/2017 within bracket reference IMDT case number 760/1998 from the office of the Fairness Tribunal, Kamrup Rural number 1. Portrait. List of 9th of January 2014.
obliged. Lord.
May it please your lordship.
Yes.
My lords, I'm deeply obliged for your lordship's permission to address your lordships virtually, my lords. Am I visible and audible, my lords?
You are very much audible and so visible.
My lord. The division bench order, my lord, is directed against the order dated 14/9/23 upholding the eviction drive And they were upholding the eviction drive and granting certain relief to 6 petitioners. We are the 9 who were not really granted the protection of possession. And may I straight away take your lordship to page 241, because on the earlier occasion, the maintainability was questioned because there was a submission, if your lordship comes to paragraph 40 at 241, when the court wanted to give 60 days to vacate, the counsel for the petitioners sought 90 days, and therefore the argument is that the writ appeal will not be maintainable. But really, my lords, on that maintainability issue, the Supreme Court has held otherwise, holding that an undertaking, in this case, no undertaking was given, but even if an undertaking is given to seek, to enable somebody to seek protection, that does not deprive the appellants from challenging it in a superior court. If your lordship comes to paragraph 40, this court, my lord, has paragraph 40. This court, during the course of hearing, was of the opinion that 60 days time may be given to the petitioners, the 9 of them who are the writ appellants before your lordship, from the date to vacate the land under the occupation. However, Mr. Nath Learned Senior Counsel, appearing on behalf of the petitioner, submitted that be granted 90 days time to vacate on the ground that it would be difficult for the petitioners to vacate the land under occupation within a period of 60 days. In view of the above submission, this court is, in the interest of justice, grants 90 days from today to so-and-so to vacate the land under occupation, failing which the respondent forest department shall be at liberty to take such action for eviction the petitioners from the land under question. My lords, on this, my lords, my learned friend may give to your lordship 1998. If my learned friend Mr. Goswami may handle, my lord, has he handed over 1998 6 SCC 507? This issue came up before the Supreme Court in an eviction matter. Your lordship knows, my lords, always to seek further time. Undertaking is sought, and therefore a question arose before the Supreme Court, which was referred then to a 3-judge bench, on the question as to whether by granting an undertaking to vacate, you deprive yourself of your right to move the superior courts. My lords, and that was answered in favor of the tenants by saying,
the land involved in the.
my lord, now if your lordship is satisfied with maintainability, may I tell your lordship the facts?
Mr. Goswami,
My lords.
whether involved before the Honorable Apex Court in that matter was related to reserve forest or forest?
No, my lord, it is not. I am only satisfying your lordship whether I am entitled to maintain the writ appeal. On merits, my lords, may I say this? The genesis of the case starts from 2002, when the first eviction drive was initiated, and that ultimately culminated in an order of your lordship. Your lordship will find that at page 58, where your lordships held, and because disputed questions are involved, therefore your lordships constituted a committee. If your lordship has page 58A, this is the typed version of your lordship's order dated 15/6/2007. My lord has that order, my lords? 58A.
59. 58. We have typed copy this.
Typed version. I can read from the original also. 59 is the original, my lord, with the untyped copy. These appellants before your lordships have been in occupation of these lands somewhere from 1978 to 85. They have built temporary, some permanent construction.
Their occupation was with due authority from the government?
No, I am not arguing on that. I will ultimately, my lords, seek a limited relief from your lordship, because the other 6 petitioners have been granted some relief in terms of the land policy of 2019. Now, the 2019 land policy says that somebody who is in occupation on or before, my lord.
Forest land? or reserve forest land?
That is the
applicable-
distinction, no, that is the distinction sought between there were 15 writ petitioners. Therefore, what this court, if your lordship comes to 59,
Whether those will be applicable for you or not, if it is on a.
my lord,
forest
I am
land-
only saying this, my lords. Now, your lordships at 59 directed a committee to do a physical inspection. And what your lordship said is that an attempt may be to resolve the issue. The authorities also understood that if your lordship comes to the operative part, may I read page 61, para 6. I quite see, my lords, what is falling from your lordship. If your lordships have para 6 at page 61, in view of the above, the writ petitioners are disposed of with direct the respondents, particularly the Chief Secretary, to the Government of Assam to constitute an appropriate committee consisting of officers from concerned departments, including Forest and Revenue, to look into the matter and to suggest to the government the actions to be taken to resolve the dispute. And if your lordship sees, 1996-2549 was quoted in that order, which is really to ameliorate. Now, after this, my lords, the committee was constituted on 2009. The first survey report comes, if your lordship has page 88.
Yes.
My lords, there are two survey reports. The High Court has relied upon the subsequent report by a private company. Now, this committee comes to a finding that my occupation of the petitioners were illegal because, if your lordship, may I read the last paragraph? After threadbare discussion, my lord has that, page 88. The committee accepted and approved the joint verification report submitted by the Divisional Forest Officer, Kamrup East Division, by letter dated so-and-so. The occupations of the appellant are found to be illegal in the South Kalapahar Forest Reserve as per joint verification conducted on so-and-so. The Google map, so it is through the Google map, my lords, along with gazette notification of and the revenue maps are enclosed herewith. The committee decided to forward the same to the government of Assam for further necessary action. Now, if your lordship sees at page 91, the report itself, because they now say that there was a notification under section 17 of the Assam Forest Regulation in 85 on 25th September 1989, by which 70 hectares of land were notified as forest land. Originally, my lords, in 68, the proposal was for 100 hectares. But if your lordship just have a look at the survey report itself, at page 90A is the type version. I don't know, my lord has that 90A, the type version. That will be a little clearer. Otherwise, your lordship may come to 91. I'm sorry, my lords, for these pagination.
Yes, please.
My lord has 90A. My lords, the proceeding of inspection survey was carried out are as follows. I'll skip, my lords, the first paragraph, the second paragraph. We, the undersigned, have conducted a spot joint verification on so-and-so in connection with the above direction of the Honorable High Court in writ petition so-and-so. And the findings are as follows. Accordingly, coordinates of Shri Ratneshwar, Kalita, and 14 others have taken during the survey time. During our verification, we noticed most of the householders constructed permanent house of the said. On researching in the field just nearby South Kalapahar Forest Reserve pillar, we verified the revenue as well as forest map and found the same land in question is a forest reserve forest land under Kalapahar Forest Reserve, which was notified during the year 1989 by notification dated 25/9/1989, and subsequently which was published in the Gazette notification 6th of December 1989. having area 70 hectares with well demarcated boundary description. In the course of our field verification, we met so and so. In connection with the above cases, they stated that during the time of their possession, they were not aware of the fact that their occupied area falls inside the Kalapahar Forest Reserve area, and about the Gazette notification regarding the South Kalapahar Forest Reserve with boundary description. The next paragraph is relevant, my lord. On being verification, the revenue Chita map and the forest map, it is seen that after Gazette notification of the South Kalapahar Reserve Forest in the year 1989, the corrections and incorporation is in respect of South Kalapahar Forest Reserve area in the revenue records and maps were not down as required in that area. So this is the basis of the first survey report, and your lordship will get the committee members. It was headed by the deputy commissioner, etc. Now, subsequently, my lords, another survey was conducted, and that your lordships will find at 117A. This, if your lordship sees, is a communication from the DFO to the Principal Chief Conservator of Forests, 4/2/2020. And your lordship, only relevant part is that they have engaged in the third line, your lordship will mark MS Precision Surveying Company. So it's a private company who have been directed to conduct survey. Their report, your lordship, on their report, your lordship will come at 119. Precision's communication to the DFO at 119. Dear sir, with reference to your letter number, so we have carried out topographical boundary survey of land using, your lordship will mark that, DGPS equipment of South Kalapahar Reserve Forest on so and so, and the same completed on so and so. During survey, we have taken boundary pillar number so and so as reference point and carried the survey for either boundary pillar as available on site with the help of your team and plotted accordingly. Further, the GPS coordinates. So both, my lord, survey, cadastral survey is not undertaken. It is through Google Map provided to us for disputed location. And there, my lord, your lordship will find that out of the 15 writ petitioners at page 119, if your lordship sees, they say 6 are outside the forest reserve. They are in government land, but outside reserve forest. And the 9 writ appellants before your lordships were found to have been inside the forest area. Now, the forest proposal came about in 19, if your lordship sees 117, there was a proposal to declare it as a forest area way back in 13th of December 1968, and your lordships will find that at page 170. That proposal, my lords, 13th of December 1968, that proposal, interestingly, was for 244 acres, which comes to about 100 hectares. But ultimate notification of 25th of September 1989, about 20 years thereafter, your lordships will find that at 101B. So 30 hectares were reduced in the final. 101A it starts, but the relevant part is at 101B. Only relevant part, my lord, is that the area from the proposal of about 100 hectares came to about 78 hectares. Your lordship will find that at 101B. 25th of September, my lord has 101B. After the first paragraph, and serial number 7 is only relevant, 70. Now, interestingly, even after the survey was provided to the government, if your lordship comes to page 85, they also understood the first order to mean that some solution must be provided, it has to be resolved. If your lordship just have a look at page 85, that's a 2020 communication. Because they were not providing the final survey, so there was orders from the High Court. But this is an order from communication from the Joint Secretary Revenue to Deputy Commissioner, dated 18 January 2020. My lord has 85, page 85. My lord, page 85, only last part I want to read. Page 85 of your lordship. This is recently as of 2020. And after the first report came about, if your lordship just have a look at the last penultimate paragraph of page 85. However, the report has not culminated in complete compliance of the order dated 2007, that is the earlier order, passed by the Honorable High Court. The aforesaid order dated so-and-so was passed by the Honorable High Court and directed the Chief Secretary to complete all the proceedings of the committee and provide the Honorable High Court with the suggestion that may be made to the government to resolve the dispute supported by an affidavit. So they also understood that what the High Court in the original order way back in 2007 wanted a solution. Now, with these background, may I take your lordships to the impugned judgment, how the court has dealt with our case and the 6 others. The basic point, my lord, there is an element of doubt regarding the accuracy of the survey report because it was done through the Google map. Today, admittedly, my lords, we are roughly for at least at page 56, if your lordship sees, we had holding numbers way back. GMC had given us in 89 at least. That your lordships will see at page 56, where the appellant number 1. Page 56. Holding, if your lordship sees Ratneshwar Kolita, and holding number is provided. And if your lordship sees the foot of the page, year is 1991. So for more than 35 years, they are in occupation in this area. Earlier, 2002, the drive was first initiated. Your lordships protected us, directed a committee to be constituted and to resolve the issue. Thereafter, my lord, there are 2 survey reports, both based on the Google map, not on cadastral survey. In fact, my lord. Now may I take...
Mr. Goswami, first tell us whether these appellants have challenged the notification by which this particular area was declared to be a reserve forest?
No, my lord, that I must fairly concede.
Let's come to page number 100.
My
Just
lord.
take as a clarification.
My lord, 100B.
Now, the particular schedule of the land which comes to be which is declared to be forest reserve.
My lord.
Isn't specified.
My lord, your lordship would see the schedule, it is little boundary description as given. My lord.
Just listen to us.
My lord.
101 is the
my lord.
This gazette notification was published on 28th of November 1989.
My lord.
Is there any power of the Guwahati Municipal Corporation to give you any
No,
such?
I am not, and that is why I am not, my lord, seeking any relief through that. I am on equity, I quite see what falls from my lord. I see the position, my lord.
Schedule is specified in Schedule B of that at page 101.
1.
Are you within that particular area?
My lord, there are two survey reports. So far, as per those
given that you have shown to us,
my
the
lord.
subsequent report,
My
not
lord.
only of Google map, but also on the basis of the revenue map.
No, that is the no, my lord, that is the critical point. The revenue map has not corrected. That is why I was showing your lordship at 91.
But the revenue map, whether it was declared forest land or not forest land, revenue map exists after this notification.
I
that
quite
should have
see-
been shown.
Your
But
lordship is
this-
absolutely right. Absolutely right. Only thing, if your lordship.
You have not challenged this notification.
No, I quite see, my lord. May I now take your lordship and the limited relief that I seek before your lordships, my lords? One thing, my lords, your lordships will notice at 91 itself, at 91, the first survey report, the notification of 25th September 89 was
Just
not
tell-
incorporated.
Just tell us more on thing.
My lord,
That report at 101, I believe, 117,
my lord,
right?
my lords,
The report starts at page
119, my lords.
15. Now, in 119, there is a particular boundary pillar.
That is
which
taken,
is
my lord.
revenue
Your-
boundary pillar.
My lord,
It's a revenue boundary pillar.
my lord is right.
It existed prior to that, prior to the 1989 notification.
Your lordship is right, my lords.
And
No, my lord, but the whole point is this. I'll tell your lordship that even between the two reports, I'll tell, so far as appellant number 9, may I just show as per the first report, if your lordship sees
Bring the
130. No, I want to show your lordship just one thing, that why it is in the area of suspicion. If your lordship comes to 137, this is an affidavit filed by the chief secretary. It starts, my lords, at it starts at 133 and 134. Your lordship will see that Mr. Pipar Senya, who is holding the post of chief secretary, had filed this. This is after the first survey report. And I just want to show your lordship one thing. At 137, if your lordship sees Roman 2, my lords, your lordship has the plot belonging to Ashwini Kolita Mukesh Rava, Ashwini Chaudhary. This is important. He is appellant number 9, page 2, your lordships will get, was found outside the notified boundary. Now, if your lordship sees 119, the second survey report, serial number 13, if your lordship sees, Ashwini Kumar Chaudhary inside the boundary. So between the two survey also there is variance. So how can we take this as a gospel truth, my lords? I know, my lord, this is a disputed question. Therefore, I would seek only limited relief. And with these background, my lords, what the High Court, the single judge said that so far as the 6 writ petitioners are concerned, who were found to be outside the reserve forest as per the Precision's report, they said that under the land policy, anybody who is in occupation on or before 28/6
yes,
My lords, now my lords, my limited relief, the basic point I was trying to project is that there is an element of doubt. That is at best I can say. Now, the learned single judge, so far as the 6 writ petitioners who were found to be outside the reserve forest, but in occupation of government land, the learned single judge said that under the land policy of 2019, anybody who is in occupation on or before continuous occupation from 28/6/2001 have a right to get some land under 14(4) of the land policy. Therefore, till their application is disposed of, they are protected. If your lordship comes to the operative part, then I can explain 200 and my lords. If your lordship comes to deals with forest, petitioners occupying forest starts from 228. Essentially, first finding your lordships will get at page 233 at 234, para 28, where the court holds at 234. just last 4 lines of the para 28 at page 234. The court says that there is nothing wrong with the eviction drive. My lord has 234, para 28.
Yes, please.
My lords, I'm just taking your lordships through the relevant finding against me also, so that lordships may appreciate. Last 4 lines. Under such circumstances, the steps so taken by the respondent forest authority to evict the petitioners cannot be said to be bad in law, for which no writ can be issued directing the forest department not to evict the petitioners who are in possession. Now, if your lordships comes to 238, the land policy is discussed from para 36.
Yes.
My lord, and what is relevant for our purpose, my lord, is somewhere in the middle of 239. In terms of clause 14.4, your lordship has at 239 somewhere in the middle. In terms of clause 14.4 of the land policy, my lord has that.
79th line from bottom.
My lord,
Yes.
my lord, the indigenous landless person who have been under continuous occupation of land since or prior to 28/6/2001 may be considered for settlement. So if you satisfy the condition, then you have some right, and this is the basis of the judgment. If your lordship now comes to para 38, 240, 249, if I may read, my lords, para 38. My lord has para 38.
Yes.
My lords, in view of the above analysis of the relevant subclauses of clause 14 of the Land Policy 2019, it has been seen that the conditions to be eligible for settlement have been duly mentioned. It is also seen that merely remaining in possession of the government land would not entitle as a matter of right to get settlement over the said land in question. It would depend upon the discretion of the state government in a manner recognized by law. It would also be seen that the maximum land that can be settled is 1 katha 5 lechas in case of Guwahati city and 1 katha 10 lechas in case of other towns as a one-time measure. Further to that, allotment settlement of land in notified water bodies, hills, ecological sites, and vulnerables to landslides and erosion shall not be considered subject to what has been stipulated under clause 14.6 of the land policy. In the background of the above, it is the opinion of this court that all the petitioners, so they are giving the liberty to everyone, including us. Petitioners would be at liberty to apply for settlement allotment of land provided the petitioner satisfies the eligibility criteria. The petitioner number 1, 2, 4, 5, 6, 7, 8, 9, 10, these are the writ appellants before your lordships, cannot claim settlement of the land under their occupation as they are occupying land within the reserve forest for reasons already mentioned in the earlier part of the instant judgment. The petitioner and other petitioner would be at liberty to claim settlement over their land. So even if they are in government land, they have the other petitioners who have been found outside the forest area. They have the right to seek land of where they are in occupation. Para 40 is what, my lords, that 60 days and 90 days is mentioned, where the court was of the opinion 60 days to vacate, we sought 90. And ultimately, my lords, at para 43 is the operative part, my lords. The next page. Accordingly, both the writ petitioners therefore stands disposed of with the following observations and direction. The petitioners, these are the writ appellants, cannot claim settlement of the land in occupation as they are occupying land within the forest areas, and as such they have to be evicted. However, they are granted 90 days from the date of the instant to vacate the land under occupation, failing which the forest department of the government of Assam shall be at liberty to evict them in the manner provided. The other 6 petitioners who are in possession of the government land have no right to remain in possession of the government land. However, this code grants liberty to the said petitioners to submit application for settlement under the occupation within 30 days from the date of receipt of certified copy, Till such application are disposed of, the concerned authorities, the petitioner shall not be evicted from the land in question. It is clarified the petitioners, including the petitioners who are in possession of the reserve forest, are at liberty, my lord. So we have been granted the liberty to apply, but directed to be displaced from occupation that we were in occupation at least at around 35 years. Now, my lords, the limited, I quite see these are very disputed questions of facts. The limited relief which I pray before your lordship is, if your lordships thinks it appropriate, extend the protection that is granted to us by another 3 months and give us the liberty to move the civil courts, because your lordship knows if we move against the government 60 days is notice. And there we can seek relief for injunctions or whatever, because these are disputed questions of fact. If your lordships grants us that limited relief, my lord, because the others, because there are 2 survey reports which are in variance in some aspect with each other. Both are based on Google Map. The revenue records have not been corrected in terms of the notification dated 25th September. Your lordships has protected the petitioners way back from 2007. And the whole essence of the first order, which the government also recognizes, is that a resolution must be brought about instead of displacing the petitioners. That is, my lords, the limited relief that I seek, my lords. Otherwise, my lords, your lordship is absolutely right. But since your lordships have already protected us since a long time and we are in occupation, and the survey report mentions that we have undertaken permanent construction. And if your lordship just have a look at the photographs, which my learned friend may place before your lordship, the roads are built. Today, my lords, if you are granting me the liberty to move an application for settlement under the land policy, my lords, then that protection may also be granted to us till they dispose of, or alternatively, really speaking, my lords, if your lordship just protect us for 3 weeks and observes that grants us the liberty to move the civil courts to question the reports now, because it is very unclear as to whether we fall within that 70 hectares or not. My lord, this is how the matter stands, my lords. And 91, your lordships may again see, because the survey report itself recognizes that this notification has not been incorporated in the revenue maps records. (90A), if your lordship sees. The last portion of 90A. This is the first survey report. (98), 90A, if your lordship just have a look at the last portion of 90A. Last paragraph of 90A.
Yes.
My lord, the last paragraph of 90A. This is an acknowledged fact.
69
On being verification, the revenue chitta map and the forest map, it is seen that after Gazette notification of South Kalapahar Reserve Forest in the year 1989, the correction and incorporation in respect of South Kalapahar Reserve Forest area in the revenue records and maps were not done as required in that area. This the survey report itself acknowledges. If it is a forest land, you are required to even translate it in the revenue records. And your lordship has seen there is variance between the two survey reports. Ashwini Kumar Chaudhary is a clear case. One report holds that you are within the forest, the other says you're outside. Even in the first order itself in 58, the esteemed senior at that point of time also said that these are disputed as questions of facts.
What is the order passed on 16th of December 2019 in this writ petition?
My lords, that is culled out in the, that is in the judgment, it is not annexed otherwise. I'll just tell your lordship.
Where it is.
No, I'm just telling your lordship. Page. Which one? Where is it, page? That order. Where is it? 221, I'm told, my lord, they deal with it. 221, if your lordship says. Where? My lord has a foot of page 221. But that is what your lordship is asking. That order is available in the website. Can I read it or send the soft copy? Because the committee was not completing its proceedings, so there was a direction. Last my lords, the operative part, may I read just the operative part of that order which I found in the soft copy?
We got it.
You got lordship has it. That is why at page 85 also, after the first report, the government also acknowledged that the attempts have to be made to resolve the issue. That is also how they understood the 2007 judgment. If your lordship sees at 85. And today we are just 9 writ appellants before your lordships.
Let me just tell us one thing.
My lords.
This report.
My lords.
At page 88, right?
My lords, 88. That is the first, my lords, the survey report.
Is at page 91.
My lord.
as well as page 119
My lord. 109.
are being.
119 is the second report, my lord, precision.
Now, these are part of some affidavits.
And these were filed, my lords, all these were, if your lordship, I'll tell your lordship, this first report, your lordship will find that 80,
Please tell us one thing.
my
These
lord,
are part of some affidavits of the respondents.
my lords, my lords.
Chief Secretary.
Okay, first affidavit starts at my lords, may
The-
your lordship,
These are part of some affidavits of the respondents that you
my
accept.
lord, my lord.
Now, after coming to know about these reports, have you challenged these reports?
No, your lordship is absolutely right. What falls from your lordship, I also quite see, my lords. But these were in the proceedings in the writ petition. They got to know during the proceeding before the learned single judge.
Challenged.
My lord, it is not, my lord, it is not. My lord, but only that is why I am coming to my limited prayer. I also, my lords, understand what falls from your lordship. The limited prayer, therefore, your lordship, is that so far as those nines, their occupation is protected, even though they are in occupation of government land, by saying that you can apply till disposal of your application under the land policy, you will not be disturbed. So far as me, because they, according to them, it falls within the reserve forest, you don't have the right to occupy the land on which you are presently occupying. Two things falls from that may disentitle me for relief under the land policy, because that continuity will be disturbed if I am disturbed. That is because you have to be in continuous possession from a date 21/8/2001 or prior. One thing that flows from it. The other, because there is variance between the two reports, so far as appellant number 9 is concerned, he was found to be outside the forest in the first report, but the private report says you are inside. Therefore, the limited prayer ultimately I'm making is protect us. Your lordship has been kind enough to protect us for such a long time, for 3 more months, and give us the liberty to move the civil courts. These are real disputed facts. I quite see what falls from my lords, because these are all, I also, my lords, it will be difficult in a writ proceedings.
Are you at Delhi?
My lords, I am, my lords. I'm so thankful to your lordship.
You are not aware what has been published in today's newspaper. In the first page.
Normally, I read the Assam Tribune, but somehow it slipped my.
Our area. And
No, I quite see, my lords. I quite see what file. But if your lordship will see the photographs, your lordships will notice that this is not one of those cases. It is, my lords, what everybody, they were accepting, giving us holding numbers. We were paying.
One thing, whether the government land is equivalent to the reserve forest land.
No, that is the distinction made by the learned single judge. And I quite see, my lords, that it is not. Because forest land, even the state government doesn't have the power to without.
Land policy of the state government of 2019, whether it has been clarified, whether forest land is the government land.
No, that they have not, but they say, because 14.6 says that if it is in hill area or slopey area, those are exception. But that is a matter which, when we move an application, it
reserve forest land.
Reserve forest, my lords, quite frankly, my lord, the reserve forest can't be within the land policy, my lord, that no government. The whole issue is whether we fall within the forest land or not. There is a debatable issue on that. If it is within the forest, I quite see what falls from your lordship. Today, there is a dispute on that. That is why, my lord, the limited prayer I'm asking, protect me for 3 months, give me liberty to move the civil courts. And there, whatever outcome will happen, we have been on occupation for 40 years. 3 months will not.
मुके गीता दादू लेखा प्रियाल गीता इंग्लिश जे रिजर्व चला के मिक्स को नहीं मिला ही लगा सब कुछ है तीन का कार्ड এটা থাকে কি বলে তিনটা থাকে না এটা উলিয়াইছে এটা দিন নেকি তিনটা নুন একেলগে আছে তিনটা তিনটা আৰু আছে ওলোৱা আৰু ইটো সৰু মণ্ডল তিনটা একেলগে তিনটা খোৱা যায় তুমি এনেকে মিলি চোৱা ইয়াতে আছে খুব প্রস্তুত ছিল এইটো কি দেখিছা ৰূপ মহন্ত দেখিছা এইটো ৰূপ মহন্ত দেখিছা এটা পালা হ'ল নে এই দুটাটো উলিয়াই থোৱা নালাগে একদম
Well, firstly, well, if my learned friend accepts, there are ultimately there are two sets of petitioners now, my lord. One were found to be inside reserve forest, and other set found to be in government land. Or in respect of government land, some reliefs were granted, my lord. So if my learned friend agrees, my lord, I can concede to the extent that their applications for land settlement under the land policy will also be considered.
That has been directed.
No, that has not been directed in respect of these appellants, my lord.
No, they have been there.
They have been directed.
My lord, to apply, they have been granted that liberty.
To
Yes.
apply there.
Yes. If they apply, we'll definitely consider. And regarding the prayer,
that is-
they should be allowed to go and assail their right established by way of a civil suit, my lord. They have, my lord, already called upon the Honorable Single Judge to decide on merit. Once it has been decided on merit on the basis of all materials, all documentary evidence, my lord.
Now just tell us what about the reports, 3 different reports.
Yes, madam. Before, yes, madam, I'm coming to that report. My lord, may kindly pay you for a moment, my lord. What was their plea before this honorable court? They obtained.
We have seen that.
No, one vital aspect my lord has not seen, my lord. It was not, my lord.
They were
placed-
evicted, they are not to be evicted. That was.
No,
the
no,
prayer.
no, I'm not on that, my lord. My lord, kindly see page 58 for a moment. That was the first petition preferred in 2002. Since then, my lord, they are continuing occupation inside the reserve forest. But on the basis of, on the strength of orders passed by
That
the.
passed by the court. That's what the order.
Yes.
We have seen that.
Page 58, my lord, my learned friend has placed before your lordship the portion that is relevant for their claim, my lord, not for the portion that is relevant for my counterclaim, my lord. Paragraph 4, my lord, page 60,
That we have seen.
paragraph 4.
That's right, we have read.
It was a submission of the petitioner that the area where the petitioners are residing have been declared as revenue forest by another notification on 89. It is their admitted case, my lord, that they are residing inside the reserve
Why
forest.
are you going for that? You see their paragraph. In that 2012, that's a repetition.
Yes, ma'am.
Para 9, page 47. They have admitted the fact.
Yes. So once they have admitted that they are residing inside the reserve forest, fortunately, my lord, some of them have been excluded because of this report. They cannot have any right to, my lord, continue inside the reserve forest. There are two laws, my lord. There are only two sections. If I place before your lordship, things will become apparently clear. Firstly, my lord has gone through, my lord, section 2 of Forest Conservation Act. Any non-forest activity to be resorted inside a forest, there has to be a prior concurrence from the central government. Firstly. Secondly, my lord, the Forest Rights Act. It says, my lord, traditional forest dwellers and scheduled tribes can be granted some rights inside a forest. For that also, my lord, a person has to put in, my lord, a family has to put in 3 generations of stay, my lord. And one generation has been defined as 25 years. So from 2005, it goes back. So the petitioners have to establish that they are staying inside that reserve forest since 1930. It is their admitted case that they settled there in 1970s, my lord. These are the 2 statutory, my lord, provisions which they are continuously flouting, my lord. Now, if my lord peruses the affidavit of the chief secretary, first affidavit, my lord, there was some confusion. That's why there are 2 affidavits filed. First, my lord, affidavit was filed that my lord finds at page 76. Page 76 is the first affidavit. Paragraph. These are our stand, my lord, in the affidavit 7, 8, and 10. It's 76. No? Paragraph 7. We, Chief Secretary, deposed, my lord, that the deponent begs to state that the committee held a meeting on 22/1/2020 and submitted the minutes of the said meeting duly signed by the members of the committee through Deputy Commissioner so-and-so, dated 23/1/2020, addressed to the Joint Secretary, Government of Assam Revenue and Disaster Management Department. Pertinently, the committee in the course of meeting and upon threadbare discussion accepted and approved the joint inspection survey report in terms of inspection and survey conducted at South Kalapahar Reserve Forest and adjacent to Jotikusi, Dokhin Gao under Dispur Circle on so-and-so, so-and-so. This was submitted by the DFO Kamrup. Paragraph 8. The deponent begs to state that as evident from the aforesaid minutes of the meeting dated 22/1/2020 and joint inspection report, survey report, as well as Gazette notification and Google Map, they are constantly harping that everything is based on Google Map. It's not, my lord. The occupation of the petitioners are found to be illegal in the South Salmara Reserve Forest. Our finding, my lord, our conclusion was also derived from the joint inspection report, survey report, Gazette notification.
First paragraph of the first affidavit, para 4, I think so. Paragraph 4. You are realizing-
Page 70. It is affidavit dated 11/3/2020.
That's right.
The other affidavit, my lord, is at page 133 by the Chief Secretary.
First affidavit starts at 76.
Yes, my lord. I'm on that, my lord. Paragraph 7 and 8 I have read. Paragraph 8, if my lord says, my lord, it's not based on Google Map, my lord. It's based on other materials. Then paragraph 10 is very relevant, my lord. Page 82. That the deponent begs to state that subsequently by letter number so-and-so dated so-and-so, the Deputy Commissioner submitted a comprehensive report on the issue involved in the instant writ petition. As per the said report, the following suggestions have been made. Number 1, Gazette notification brought out in the year 1989 dated so-and-so declared 70 hectares of South Kalapahar area as reserve forest as per boundary specifications. Number 2, no encroachment of any kind right compensation was made at that time. That means they were not there at that time, my lord. Hence, it can be safely surmised that the encroachments took place in a much later date. No documents, evidence have been submitted by the petitioners to counter their encroachment occurred before the date of notification. The revenue receipt submitted by one of the petitioner as a proof of his possession dates post the date of gazette notification and is a plot of land not associated with the land under dispute and is in the name of an altogether different individual and hence it found irrelevant to the case. At the hindsight of the actions of the petitioners violate the provisions of the both Assam Land and Revenue Regulation and the Forest Regulation 1891. This is, my lord, based on a report. I will come to that report, my lord. Before that, my lord, may kindly peruse page that 91, my lord, has already seen. But 91 is bit illegible, so I would like to take a lordship to page 112. Same copy, my lord. 112.
It's quite legible in our copy. I don't know, madam. Yes.
112, my lord, is more legible. One of the grounds taken, pleaded grounds in the writ appeal, my lord, is that when the joint verification reports was conducted, none of the appellants petitioners were heard. That is one of the pleaded case. That is their ground number 6. Now, my lord, may kindly see. They are saying it is based on Google Map. Everything is on Google Map.
Yes.
Serial number 1. On researching the field just nearby South Calabar, so this, my lord, 2 paragraphs, my lords, have already seen. That has been placed by my learned friend, my lord. Paragraph 2, my lord, will see. In the course of our field verification, we made Sri Dinesh Das, Sri Mukesh Rava, Sri Ratneswar Kolita, Sri Koruna Sohoria in connection with the above mentioned cases. So their ground that they were not heard, they were not present, doesn't survive. They stated that during the time of their position, they were not aware of the fact that their occupied area falls inside the Kalapahar Reserve Forest and about the Gazette notification regarding the South Kalapahar Reserve Forest with boundary description. Next 2 paragraphs are relevant, my lord. On being verification of the revenue Sitha map, not Google Map, my lord, and the forest map, it is seen that after Gazette notification of the South Salmar Reserve Forest in the year 1989, the correction and incorporation in respect of South Salmar Reserve Forest in the revenue records and maps were not done as required in that area. It was initially not done. Next paragraph, my lord, will see. The geo coordinates of concerned household were taken, which are enclosed there with. Geo coordinate doesn't mean, my lord, Google. Google also takes help of satellite, my lord. These are satellite maps. The occupation of the some of the appellants are found to be illegal in the South Kalapahar Reserve Forest as per joint location conducted on 8/7 so and so. The Google map along with the Gazette notification and revenue map enclosed here for your ready reference. Google map forms one part of the record. Next page, my lord, will kindly see. How do they overcome this, my lord? This is the geo coordinates, my lord, under which they are residing, which will tally with all satellites, my lord, be it Google map, be it any other map, my lord. These are derived from GPS mapping, my lord. These coordinates, longitude and latitude, my lord, are precisely correct, my lord. They cannot get out of it, my lord.
Yes.
Then, my lord, will kindly see that this is letter, my lord, 23/1/2020, that the affidavit of Chief Secretary referred to, that my lord finds at page 87. My lord, it's too late in the day for a person to...
Also available at 116.
Yes, my lord.
Great.
21 to 2020, my lord. Just a minute. Yes, page 105, I'm sorry, ma'am. 105.
Yes.
This was addressed to the Additional Chief Secretary, Revenue and Disaster Management, my lord. With regard to this case, it is pertinent to mention that whole petition is about the eviction drive carried out by on the encroachment of the South Kalapahar Reserve Forest area by the Forest Department on 7/2/2002. Letter challenging this eviction drive so carried out, several petitions were filed by about 15 residents, petitioners of the evicted area in the Guwahati High Court. These are the background, my lord. After the High Court order, this was the committee constituted. We can skip, my lord. In 2009. Then last paragraph, in this regard, a meeting was held on 29/5/2012 in the office chamber of Additional DC, Kamrup Metro, in compliance of the High Court's order dated so and so. This was the steps, my lord, consequent to the first order. Next page, my lord, may kindly turn. But after doing all this exercise, my lord, all this verification, joint verification, the finding the report is at the last paragraph, my lord, of 106, which was, my lord, quoted in the affidavit. This is precisely the reiterated in the affidavit, my lord. There is no challenge to this. Then, my lord, will kindly see.
Yes, next.
Next, my lord, I would like to take your lordship. So admittedly, my lord, these petitioners are inside forest area. Even assuming, my lord, they are not inside forest area, they are inside government land, my lord. If they are inside government land, my lord, assuming for a moment, my lord, though not I am admitting, my lord, then also, my lord, they cannot resist an eviction. At best, they can make a claim for settlement under the land policy, which we are ready and willing to accept and consider, my lord. Even if they are inside they are over a government land. And if we consider, my lord, they are to be inside of reserve forest, which, my lord, every records indicates, I would like to take your lordship to the Forest Conservation Act, my lord, 1980.
Please submit.
Forest Conservation Act 1980, page section 2, my lord.
Yes, please read, please.
Yes, it says, my lord. The heading is like this, my lord. Restriction on the de-reservation of forest or use of forest land for non-forest purpose. Notwithstanding anything contained in any other law for the time being in force in a state, that means state law has no role to play. No state government or other authority shall make, except with the prior approval of the central government, may order directing, serial number 2, that any forest land or any portion thereof may be used for any non-forest purpose. So construction of a residential house, my lord, by no stretch of imagination, can be considered as a forest activity, my lord. Now they are with all boldness, my lord, submitting photographs to indicate the concrete roads are also made, my lord.
Yes.
And next, my lord, the Scheduled Tribe and Scheduled Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. My lord, commonly we call it as the Forest Rights Act 2006. In a short form, my lord. That Forest Right Act, my lord, is meant to protect some interest of, my lord, forest dwelling scheduled tribes and other traditional forest dwellers. They are granted some rights, including, my lord, right of possession of land. But, my lord, this act is applicable to a certain class of person which the appellants cannot claim. But I would like to take your lordship to definition section 2C, Forest Rights Act. 2C is forest dwelling scheduled tribes. It is not their case that they are scheduled tribes, so we can skip this, my lord. Next is the other traditional forest dwellers. Only other traditional forest dwellers can have claim inside the forest, reserve forest. And they are defined as, my lord, other traditional forest dwellers means any member or community who has for at least 3 generations prior to 31/12/2005 primarily resided in or who depends on the forest or forest land for a bona fide livelihood needs. So for 3 generations up to 13/12/2005, they have to reside inside the forest. And most importantly, my lord, they are to be dependent on forest and forest land. These persons, my lord, they have already destroyed most of the forest. The question of dependence over the forest doesn't exist, my lord. It is basically exploitation of forest, my lord. They have cleared the forest, not resided along with the forest. And it has also been defined, my lord, the generation would mean a period comprising of 25 years, 1 generation. So 3 generations will 75 years. With retrospective effect from 2005, it goes back to 1930. Then, my lord, the second affidavit, another affidavit of fixed secretary at page 133, my lord.
First time we'll take Mr. Goswami.
My lords,
Concluded almost, my lord. Because my,
Sister has to sit in single, large number of bail petitions.
my lord, take it up tomorrow, my lord, then.
खाली किमान के चाहिए?
I will take hardly 10-15 minutes, my lord.
Why so many bills before Christmas? Seems only for 2 voters, I think that this court will say. We'll have it tomorrow.
deeply.
Mr. Goswami, you finish it. Mr. Goswami, Senior Goswami applied.
My lord, allows me tomorrow 5 minutes, my lord. Only 5 minutes I will take, my lord. Then there will be some continuity, my lord. 5 minutes for tomorrow, my lord.
My lords.
Sharma.
Deeply obliged, my lords, deeply obliged.
We'll have it tomorrow, Mr. Goswami.
My lords, deeply obliged.
Where is Mr. Fine, Mr. Goswami? Sharma, you have gone through the records?
Yes, sir.
Have you seen?
Yes.
What is the submission?
Lordship, reference was made, although inquiry is not separate inquiries, although not there, Lordship. Reference was made against the whole mean, Lordship. And Lordship, otherwise, Lordship, a proceeding is getting so much opportunity before the tribunal to prove his case. Deliberately, he neglect the proceeding, Lordship. It is in the record, Lordship. Lordship. Otherwise, Lordship, I leave it to your Lordship.
Mr. Fine. Initially,
Yes,
the proceedings started with the number 1 petition, right?
that's
During the inquiry, they have also named the entire family member.
yes.
But the reference was not only with the petitioner number 1, but also his family member.
Yes.
What do you have to say?
That is true, my lord. The inquiry, in fact, inquiry also,
First name is the petitioner.
yes. And during inquiry, the my lord, inquiry officer found my lord defect.
That's true. But the reference, show it to Mr. Lockhart. The reference to the tribunal, IMDT.
And
Yes.
his family member. They are entered India.
They are specifically named, not personally named, but the entire family member.
Yes.
So, and it was not the case of the petitioners before the tribunal. The reference was not against them because notice was issued to all of them. You see the notice?
Yes.
Available
Yes,
in
not,
the
not,
record.
yes,
It
notice was
issued to
issued to all of them.
All of them.
That's true. They also participated in the proceeding, all of them participated in the proceeding.
My lord, in fact, my lord, petitioners filed at WS, my lord. Thereafter,
Yes.
my lord, due to certain reason, my lord, due to non-ability of documents, my lord, they could not appear before the tribunal, my lord. And ultimately, my lord, the case was fixed for evidence, my lord.
Pursuant to the order,
My lord, at this stage, my lord, I pay for bail, my lord. You'll also be hard.
dated 11/12/2023. Mr. C. Sharma, Standing Counsel from the Department.
I have also, my lord,
Place
similar
the
judgment, my lord.
FT within bracket C 26/2019. Of the Foreigners Tribunal #1 Morigaon. Wherein the said tribunal by judgment and order dated 07/06/2017. Opined the petitioners hearing to be foreigners under the Foreigners Act 1946 of 25/03/1971. However, the petitioners have preferred this writ petition against the said order dated 07/06/2017. Opinion dated 06 of the Learned Foreigners Tribunal noted above. Only on 08/12/2023, when they were taken into custody pursuant to the said impugn opinion dated such. Taken into custody only on, taken on 31/10/2023.
No, my lord, it's 4/11, my lord.
4/11/23. Pursuant to the said impugn opinion dated such and such. Without explaining any reason for the delay in preparing such information.
I have explained, my lord.
After more than 6 years. Placed on third.
Can it be on fourth? Lordship?
Fourth.
Yes.
May I pray, my lord? The for, in respect of item 19, my lord, this is a criminal appeal, my lord. He accused in jail. Otherwise, the paper book supplied. Now only what are it? Let the matter be listed for final hearing after any date, my lord, leave vacation.
Have you filed any application for early hearing?
No, today for orders, because paper book normally as usually after paper book it will come for hearing. The paper book we have received. Only today order your lordship will, my lord, please to list the matter, paper book supplied, we have received the paper book.
Your bail application was rejected earlier?
Yes, ma'am.
POCSO case?
No, 302. Life imprisonment.
Then appeal of 23.
Yes, ma'am. Paper book prepared in terms of earlier order, ma'am.
On the prayer of the council for the petitioner. Sorry, appeal. Place this matter for hearing.
Any date after leave vacation?
In its usual course. However, it is made clear, subject to filing of any such application for early hearing order matter. The court will consider it.
Already there is an order, my lord, earlier. Court order to prepare paper book. Considering that from 2013,
Other matters are pending.
he is, my
We are
lord,
not
English.
discriminating with any accused person. Are we?
Already there is observation, man. Since matter is long pending, man, he is, since long time he is in jail.
Since when?
13, my lord. Take to correction. Already there is order.
There is a rejection of the bill. Where you have stated that he is in jail since 2013 after taking the president.
I think something, there is observation in IA, my lord. IA last order, your lordship will take. He was,
Judgment was of 2022.
yes, my lord, 22, but he was during in the entire course of trial, he was in jail, my lord.
Where you have stated so.
So that is my appeal in application already rejected for bail. Therefore, this honorable court was
The
pleased.
application for bail where you have stated so.
That was not earlier set of counsel, that statement I have not. But considering that aspect of the matter, my lord, the court directed to prepare
So I
paper.
wanted you, Mr. Aizkin, you know, you should be very specific. If there is a mention there, you will.
Initially, I was not my lord engaged
Then
counsel.
you file an appropriate application. also.
But that. Not, my lord, let the
File an
matter be.
application, we'll consider.